Hello, I'm Christopher Snedden. Welcome back to Tushita Talks to the World. Today, Jonathan G. Odom is going to be speaking with us. Now, it's wonderful to have John here because John is one of the few Americans who's been to our place in Central Victoria. He and his family stayed here a few years ago. And so John understands where we live and a little bit about our place. Apart from that, he is a judge advocate, which is a licensed attorney in the United States Navy. Currently, he's serving as a military professor of international law in the College of International and Security Studies at the George C. Marshall European Center for Security Studies in Garmisch, Germany. His principal areas of research and teaching are public international law, maritime security, and international territorial maritime disputes. However, he's had a long naval career during which he's provided legal and policy advice on matters involving international law and security to US and multinational military commanders, headquarters staffs and forces around the world for military operations at sea, in the air and on land. He's also, in his personal capacity, published law journal articles, book chapters and opinion editorials on various aspects of the law of the sea, the law of airspace, the law of armed conflict, national security law, national security strategy, oceans policy, maritime security, homeland defence and negotiations. He's been a busy man, in other words. And today he's speaking to us about aspects of some of these, but also it's his opinions, his personal opinions. He's not reflecting any official organisation. So it's great to have John with us. Welcome back, John. Great to see you again.
Great to see you, Chris.
So through past interactions, I remember one of the things that we spoke about in Honolulu on more than one occasion was this wonderful concept of lawfare, the use of law as a weapon of war, or the strategy of using or misusing law as a substitute for traditional means to achieve an operational objective. As per Colonel, as he was then, Dunlap, he was one of the ones who publicised this particular concept. So international law is, for me, something that's rather vague and amorphous in the sense that it seems that there's more than one type of international law. It's not agreed across the board the way perhaps national law is. And in Australia, for example, we have our High Court, which is the ultimate arbiter. In the US, you have the Supreme Court, which is the ultimate arbiter. Here we have arbiters, but their decisions are, it seems to me anyway, not enforceable. So can you tell us a little bit about international law and how effective has this strategy of lawfare been in terms of its use by various nations? The Chinese, for example, call it legal warfare, I understand. Right. So tell us a little bit about lawfare, please, John.
Yes. So with regards to lawfare, as you mentioned, General Dunlap, who's a retired Air Force lawyer in the U.S. Air Force, and he's now a professor at Duke University. He really started using that phrase in 2001, late 2001, early 2002, to describe some of the tactics that the Taliban and Al-Qaeda were using in Afghanistan, where they're putting their military encampments in civilian populations because they know that U.S. and coalition forces are not going to bomb that location if it's going to result in significant death and loss of life and injuries to civilians. So they're leveraging the law to their advantage because the other side, like the Australian forces, the U.S. forces, other countries' forces that were engaged in the combat, are going to try to comply with that body of international law. So it's oftentimes it's used by a less powerful party to a conflict or an activity because that's what they have to leverage against the more powerful party. The irony is my understanding is while Dunlap brought that phrase up and started making it very popular among international lawyers and legal experts, it actually goes back to a couple of Australian scholars that were using it in the mid-90s. And they were talking in the context of domestic litigation, trial work. And they were saying that lawyers need to be able to engage in lawfare in the courtroom. But really Dunlap took it into the realm of international law.
So Australia really is the centre of the legal universe.
Precisely. Those are not words in my mouth. You said it yourself.
So do you think it's been effective then as a tactic, a strategy?
Yeah. So I had a professor for one of my masters of law who he very much frowned upon the phrase lawfare. And he had been the legal advisor to the National Security Council under President Clinton. And he was of the view as it was saying, you guys are whining too much. You're complaining the other side's making you follow the rules. Well, guess what? You're obligated to follow the rules. And so I also think I try to stay away from the phrase really because it also, it's an academic term. It's not what necessarily governments are using when they say they're going to take actions. The Chinese doctrine, the military doctrine, which is part of their government, the PLA, is they do use the phrase legal warfare. But I also think that when you use the phrase lawfare, it kind of, the diplomats can tune you out because they're like, hey, we don't engage in warfare, so stop putting war type language into what I do in foreign policy and diplomacy. And so I prefer now more to use the phrase legal gamesmanship. And I'm not trying to sell bumper stickers or T-shirts with it. But I just think it more captures what the Chinese are doing. And that is, there's great power competition going on. The U.S. government says that, but I think it's an empirical fact that there is competition going on between the United States and China. And so as a result, in that competition, you try to use the rules to your advantage. And we see the Chinese doing a lot of that. So, so as a result, it takes takes it less out of being a pejorative thing and saying, oh, only the bad side or only this side does lawfare. Yeah.
So that legal gamesmanship is the cut and thrust of international politics.
Exactly.
Well, and when you're talking about cutting as well, then we can talk about salami slicing, which I don't know. Sure. Certainly, the Chinese have been accused of salami slicing, but it's not the only nation that engages in that sort of activity, I don't think. So we can't blame the Italians for everything.
So I think that I think the salami slicing blends well in a discussion in talking about legal gamesmanship because if I'm trying to do things that stay below the threshold of cause to go to war, and so I slice off individual pieces of the salami, and I never rise to the level of being an act of war. That's the old phrase before the UN Charter. But if it doesn't rise to the level of being an armed attack, which is the phrase of the UN Charter, then I never give you a reason of why you have the authority to invoke your right of self-defense, right? So I keep doing things that are below that threshold, and in a long period of time, I'm able to accumulate enough of the salami where if I would have cut off half the salami in one slice, you would have said, well, that's an act of war or that's an armed attack.
Yeah, and it's obvious that because you're missing half the salami. So in terms of international law then, there are various conventions as well. And one of these that's very significant, and I know you've spent a lot of time looking at, is the United Nations Convention for the Law of the Sea. Sure. And there's also a number of legal bodies that adjudicate or arbitrate on issues to do with that convention, such as the International Court of Justice or the Permanent Court of Arbitration. It's interesting, though, in terms of that particular organisation, the Permanent Court of Arbitration, its decision in 2016 on the Filipino case that was taken to it by the Philippines, which stated that China has no historical rights based on China's so-called 9-dash line to the South China Sea. China did not partake in that particular action, nor did accept the decision. So how useful is the UNCLOS, the United Nations Convention for the Law of the Sea, and the arbitrations resulting therefrom?
Yeah, so I think that, that one decision cannot demonstrate that therefore the entire legal regime reflected in the convention is powerless or defective, because that's kind of one of the constant frictions in international law. Nations engage in negotiations, they conclude treaties, whether they be bilateral or multilateral, and then afterwards there may be disputes over how to interpret or apply those provisions of the treaty, and there oftentimes are dispute forums that are recognized within the language of the treaty that says if there's a dispute between two or more parties, they will go to this forum to resolve the dispute, whether it be through negotiations or through litigation in an international court or arbitration. So I think that case brought to fore that there is challenges when it comes to, at the end of the day, the international legal system is not the same as a domestic legal system. It simply is not. And so you don't have a police. You don't have a way to necessarily fully enforce the rulings, but that doesn't make them as a matter of law any less binding. So the language of the treaty is clear. That particular treaty is that the tribunal that arbitrated that case, their decisions, whether they had jurisdiction over the case, are final. And they are binding. They shall be binding upon the parties. So it's an empirical fact as a matter of law. That ruling is binding on China, no matter how many times they say they don't believe it, they don't want to follow it, they don't want to respect it. And their vice foreign minister, the day after the ruling came out in July 2016, called it a piece of waste paper. And so I think that kind of demonstrated almost like a Rorschach test. It told you what Beijing thinks of that provision of the treaty. They don't like that there is sometimes law that's above the party. And so that it presented a challenge. And so, a number of countries, including the United States, including Australia, including Indonesia, Malaysia, and Singapore issued statements after the ruling saying, we call upon the parties to comply with the ruling. And then they kind of took a step back there in July 2016. And so a number of countries just waited, hoping that, this would now be the next, China and Philippines would move to the next stage and negotiate. And instead, China just continued to disregard it, while the Philippines said, hey, we really want, we need to follow this ruling. So there was a 3.5 year period where people were like, oh, well, I guess the ruling's dead. But then this year really changed. The U.S. issued a statement on the 4th anniversary, which was a very strong statement saying that how they were going to fully implement the ruling as a matter of U.S. foreign policy. But more importantly, Malaysia, Indonesia, Vietnam, Philippines issued statements soon coming up on the days before the ruling, which in the 4-year anniversary of the ruling, which spoke of the ruling for the first time in years. Mm-hmm. And so it's almost kind of like these nations are realizing that there were some very helpful solutions that the ruling offered, ways to move forward on these disputes. And they're like, oh, well, we could go back to that. We need to revisit that. So I think it's kind of resurrected itself, and we'll see what happens.
And I saw today that ASEAN and the People's Republic of China are due to have some sort of a meeting about the South China Sea in November, I think. So
yeah, I think they're supposed to resume negotiations over the code of conduct.
Yeah, well, that's a positive, I guess, isn't it? That
exactly.
They're doing
right.
it. So a related issue is the famous, perhaps misused term FONOPS, Freedom of Navigation Operations, which not many people know that acronym, I don't think, or that term. And it's very important to the United States, the nation from which you come, with senior US officials publicly declaring on occasions that the United States, and I quote, will continue to sail, fly, and operate anywhere that international law allows. Now, most recently, in recent years, that's been quite controversial, certainly from Beijing's point of view. So do you think the US is going to continue to use FONOP? Is it a useful device? Has it had any success in terms of influencing China?
Well, I think one of the key things to note at the outset is that what has changed. And what I mean by that is the U.S. Freedom of Navigation Operation Program, or the U.S. FON program, has been around since the late 70s under President Carter, and then it fully was invigorated by President Reagan in the 1981-82 timeframe, and it's been alive since then. There was the operational tempo was a little slower on the number of free navigation operations that were happening around the 9/11 period, 2001, 2002, because U.S. Navy ships needed to get to the Gulf. They needed to get off the coast of Afghanistan, Pakistan for operations as soon as they could, so that they could engage in the operations they need to there. But other than that, there's been a resurgence in the recent years of the number of operations that have been conducted around the world. But the U.S. has been doing free navigation operations in East Asia, including the South China Sea, since the 1980s. And so that hasn't changed. The U.S. has continued to do those over the past 40 decades. So what's different? Well, obviously China is different. China probably didn't like it back then, but a lot of coastal states aren't necessarily in favor of someone challenging their excessive maritime claims. But clearly China has more capability now. That's what's different, right? They've been able to do military basing or emplacements there in the South China Sea on some of the smaller features, including turning some submerged features into artificial islands. And so China's capabilities have increased, and their voice has become louder on the international stage. So it's not that the U.S. has all of a sudden started doing freedom of navigation operations. They've been doing them for 40 years. In some respects, it's part of this great power competition.
One of the things that I've considered is the use of terminology, and part of the challenge for the South China Sea is actually the name itself. And in my particular area of expertise, South Asia, the Indian Ocean, there are some Indians I've met who believe that the Indian Ocean is named after the modern state of India, in other words, the state that came into being in 1947, which is totally incorrect, of course. The Indian Ocean has been called the Indian Ocean for a long time, at least 1,000 years, perhaps even longer. But if the Indians think it's the Indian Ocean because it's named after India, then one way around that issue would be to change the terminology. Same with the South China Sea, which I think already Vietnam is calling the East Sea, and the Philippines is calling the West Philippines Sea.
Right.
Why don't we just call it the Pink Sea? Because that would then change the dynamic of the problem. And I say the Pink Sea because we already have in the world the Yellow Sea, the Black Sea, the White Sea, and the Red Sea, but we don't have a Pink Sea. So how important then is terminology in this dispute? And in relation to that, how serious is the Chinese 9-dash line? Because it used to be up to the 11, I think even the 13-dash line at some stage, and it seems that it's only come into being after World War II, so sometime maybe around 1947, I think. So,
correct.
Would you like to say something about both of those, please, John?
Sure. So on the first point, the fortunate thing is that tribunals and international tribunals, when they look at cases when it comes to maritime disputes, for example, the name of the body of water is not dispositive. That is, it doesn't control and dictate whether one country owns it or not. Now, as a political matter, you could emphasize, oh, that's my sphere of influence, if you wanted to say that, if you were a particular coastal state, and say, China could say, the East China Sea, clearly we are allowed to be there. And we're like, of course you're allowed to be there. We're allowed to be there too, because what controls is international law. And so it's the law of the Sea Convention, which Ambassador Kami Ko, that was president of the conference that negotiated the law of the Sea Convention, he called it the Constitution for the Ocean. And so it's important to understand what matters when it comes to where you're allowed to be and what you're allowed to do in that water space is not whether the name of that body of water has some sort of historical nod to the name of your country, but rather who gets a 12-mile territorial sea off its coast, and what are they allowed to do in that water? What are other countries allowed to do in that water? Who gets a 200-mile exclusive economic zone off of their coast? What are they allowed to do? What are other countries allowed to do in that water? So that's what controls. And in fact, there's a lengthy history of cases where courts look at maps and charts and say, guess what? The mere existence of a map is not dispositive as to who this belongs to, because it has to be placed in context. Who issued that map? Was it a government? Does it clearly define what that country claims? Have other countries acceded to that claim? Have they not protested it over a period of time? And so one of the dynamics is going to like the 9-dash line. you're right that it dates back to 1947, 48, under the Republic of China, that is Taiwan. Chiang Kai-shek, as soon after the war, sent his naval forces down to the South China Sea to do a survey of features in the South China Sea that had been occupied by the Japanese, Imperial Japan. And so they went down, they came back, they brought this map, and it included these dashes. And there's a scholar that's gone through, a young scholar went through from Canada about 4 years ago, great article where he went into the archives in Taipei and essentially said, what were they claiming at that time? Or what were they claiming internationally, but what did they believe within the inner circles of the Republic of China government that those dashes meant? And ultimately, he determined it was just supposed to mean a line of allocation. That is, the features, the islands that were within that line were claimed by Republic of China. And it was not intended to be anything about some sort of special status of the waters. So that's huge. That was the original, that was internally, setting aside what they advertised to the world. So then you move forward 2 years later, the PRC is born in 1949. And then decades after that, they start referring to that map, but they never clarify what they intended for it to mean. It seems to be something more than just a line of allocation to Beijing. But they've never publicly said what it is. And at the same time, they have tried to say, look, we've had this for decades and no one has ever protested it. Well, Chris, if I had something in my notebook at home about Tushita, and I said that Tushita belonged to me, but it was only in my notebook at home, and you'd never seen it, and you couldn't dispute that I said I claimed Tushita, and then I wake up 50 years later and I say, look, I told you Tushita belongs to me, and you're saying, but you never told me that. You never made that allegation, so I didn't know that I was signing up to this. I wasn't consenting to that. So I think that's just a very simple analogy that it's very convenient for China to say 50, 60 years later, well, we've had this line for years, but they've never clarified what it meant. And in fact, the original intent of it under Republic of China was just some sort of claim to the islands within the line.
That's very interesting because in a conversation recently with Mohan Malik, he said the same thing in relation to the disputed India-China border, that China never actually produces maps to say this is where we believe the border is. It's always very vague. It's somewhere here. And again, they're pushing the envelope a little bit as well. The other one that's interesting too is that Taiwan, the Republic of China, actually also agrees with the People's Republic of China on a lot of these territorial disputes, I understand.
So they have the dash line as well, because obviously it originated with them.
Yeah.
And they have tried to diplomatically navigate their public statements to harmonize that with the Law of the Sea Convention. But at the same time, there is a certain element of nationalism going on both sides across the water between Beijing and Taipei as to who can be the effective representative of the claims in the South China Sea for a Chinese people, right? So.
Yeah, and I guess it's a device they can use in terms of gamesmanship between both of them, to say we're more nationalistic, more Chinese, I suppose, than the other.
Yes.
So I'd like to speak a little bit about the Republic of China, or Taiwan, because the United States has an incredibly interesting relationship with that entity. I don't call it a nation because it's not a nation, but we can call it an entity because it exists. We know it's a member of APEC, for example, the Asia Pacific Economic Cooperation Grouping. The relationship involves three things that I think are important: the 1969 Taiwan Relations Act, the three joint communiques between Washington and Beijing in the 1970s that established the US-PRC relationship diplomatically, and the 6 assurances provided by President Reagan to Taipei in 1982. So how does Washington DC resolve its relationships with both the PRC, People's Republic of China, and also its need to have a relationship and indeed perhaps protect Taiwan from aggression from China?
Yeah. Well, clearly it has a difficult time doing it.
Yeah.
No, navigating that nuance in the international system. in the sense that obviously the U.S. for decades had a longstanding formal relationship with the Republic of China until you, as you said, establishing diplomatic relations with the PRC. But the United States was not willing to walk away from that, the legacy of that relationship. And obviously at the time, as they were walking away, it wasn't a democratic Taiwan that it is now. And you have, decades of independent histories of mainland China and Taiwan. And there's a certain amount of, over a period of time, if we live apart, we become different people, right? And whether it be you and I living in two continents, if we're seeing each other every day, interacting, and we feel like we're part of the same community, that's one thing. But now that you're in Australia and I'm in Europe, we miss out on that part of that relationship. Sure. And I think that what you see with Taiwan is the people that live there now consider themselves less and less Chinese. They consider themselves to have their own independent life. And while the government or the leaders of Taiwan may not formally declare independence, the reality is if you tried to integrate those two places, we'll call them both entities, one being the PRC, one being Taiwan. If you tried to integrate those right now, it would be a mess because you have people in Taiwan that would not want to be part of under a government regime, the one that exists in Beijing. That's just antithetical to what they believe in. So I think there's that aspect. There's a long history between the U.S. and Taiwan. And also it's an indicator of security and stability in the region. So if the PRC is willing to use force to get its way in integrating with a forcible integration of Taiwan, just like we've seen what has happened in Hong Kong in the past several months, it is a wake-up call to other countries in the region, like Vietnam, like Philippines, like Japan, like South Korea. What more is Beijing willing to do to get its way? So that's, I think, the bigger concern. What's its impact on regional security and stability?
Well, yeah, and that's really interesting too. Because what is the impact on regional security and stability? And I'm thinking in particular of how the military balance has changed in Northeast Asia. Now, Northeast Asia is an incredibly interesting area because of the territorial disputes. And I'm not just thinking of the South China Sea. We also have Japan and Russia contesting ownership of the Kurils, or the Northern Territories, as Japan calls them. Japan and South Korea contesting ownership of the Dokdo or the Takashima Islands in the Japan or the East Sea, and also Japan and China, the Senkaku Diaoyu Islands in the East China Sea. So it's an incredibly volatile area, and clearly the military balance has altered as China is becoming more powerful, now having 2 aircraft carriers, but it's still a long way behind the United States, which not only still has, I believe, 11 carrier battle groups, but it also has these wonderful extensions, these strategic extensions that give it strategic reach through things like Guam, and also the very significant relationship with Japan, and also indeed my nation, Australia. So how do you think that this area is going militarily? Is it something that we need to be concerned about? Is there going to be armed conflict in the next 5, 10, 20 years? Or do you think, and we're talking about how things stand at the moment, there could of course be regime change. There certainly will be regime change in the United States. Maybe not this presidential election, but certainly at the next one. So China, we don't know, but there are apparently, there is some unease with Chairman Xi Jinping at the moment. So there's some issues there. But how do you feel about the military situation in the volatile Northeast Asia area, John?
Yeah, sure. So personally, I don't see there being an intentional armed conflict between any of the Northeast Asian neighbors. I just don't see China waking up one day or Japan waking up one day and saying, you know what, I think today I want to go a war against my neighbor. I just don't think it's there. I think that they recognize they have too much at stake, including, but not limited to, their economic interests for that to happen. And so I think the bigger concern is an unintentional conflict. And that is some sort of incident in which military forces on each side are operating in proximity to one another, just kind of routine operations or patrols, or one is conducting surveillance flights near the other, but lawfully in international airspace. The other one doesn't like it. They go up to intercept that aircraft and escort it, and then something happens. They miscalculate, or they misinterpret intentions, and then an incident happens and it spirals out of control. And then it's a matter of the leaders of those countries trying to put the genie back in the bottle. So I think there's been progress in the past 8 to 10 years so of some of the bilateral relationships in each of those countries, whether it be between Japan and China in trying to work out mechanisms to reduce that risk of misunderstanding or escalation. The U.S., I was part of the negotiating team that negotiated a bilateral memorandum of understanding with the Chinese about 5 or 6 years ago about how our ships and aircraft would operate safely around one another. And we made sure it recognized and reflected our maritime and air freedoms that both sides had. But we also have a shared interest in not having one of these incidents spiral out of control. Since that, in my writings in the past 2 years, one of the things I've tried to start asking the question is, what if some of our assumptions are wrong? That is, what if Beijing is saying to Washington, no, we both have a converging interest in being safe and not having a risky situation get out of control, when in fact Beijing's willing to incur more risk than the U.S., and they want to engage in what I call risk-fare. So you talked about lawfare earlier. What if they're willing to engage in what I call risk-fare? That is, using risk as a weapon of warfare. So instead of me firing off surface-to-air missiles at a U.S. aircraft, trying to get them to leave or to shoot down that aircraft, I know that would be an act of war. What if instead I send one of my aircraft, my fighter jets up near, or 2 aircraft up near one of your planes, and I start surrounding them and engaging in unsafe behavior, and in hopes that you will eventually say, you know what, this is too risky, and my government leaders pull me back and I stop doing that operation. If I did that and I deliberately used that risk as a weapon to achieve the same effect of keeping you out of that area, then I've achieved my goal, right? Without going to war. It's similar to the salami slicing. So on the one hand, I don't think there's going to be an intentional armed conflict, but on the other hand, there is going to be probably increased risk, in part because there's more presence of everybody in the space, and some may be more tolerant of risk than others.
So that's going to put militaries on both sides under enormous pressure, isn't it? To go close, but not. It's almost like Russian roulette.
So, from the nuclear age, you would call it brinksmanship to a certain extent, right?
Yeah.
But the reality is there's this kind of strategic level decision-making and this tactical level decision-making.
Yeah.
And so one aspect of this is what are the pilots or the ship drivers empowered to do at their local level? And what are they prohibited from doing? And more importantly, how effectively are they trained to operate their ships and aircraft? Right? And have the leaders given a lot of latitude to those ship drivers or those pilots, a lot of discretion to maneuver within that space and to take certain actions. About a month ago, the Chinese, it was announced in the South China Morning Post that the Chinese leadership, their government, had issued a directive to their forces that the Chinese forces would not fire the first shot against U.S. forces in these interactions. And so you view that as a positive step. I think it's a positive step. I mean, but at the same time, it kind of begs the question of, if they issued that order then and they knew that the Chinese forces were going to follow it, but yet for the past 10 years, Chinese forces have been operating unsafely around U.S. forces in the South China Sea and East China Sea, it kind of begs the question, couldn't they have just issued an order 10 years ago, don't operate unsafely? Or it does call into question, or did they say, you can do these kind of activities, these unsafe activities? I don't know the answer to that, but it's definitely something to ponder.
It is indeed. The final question, John, I'm interested in your personal opinion about Chinese-United States relations, say in the next 20 years. How do you think they're going to go in the next 20 years or so?
Yeah, it's a great question. I think
I know it's slightly outside your field, but I'd just be curious to know.
Yeah. Well, I think that great power competition is here to stay. Or whether you call it, different countries may, in different political regimes might use a different bumper sticker to label it. I don't know if you have bumper stickers in Australia, do you?
Yes, yes, we do, but we haven't had them for a while.
Exactly. So, but I think that the reality is that the U.S. and China relations economically and so many levels are intertwined, and they have been for decades. So this whole idea of decoupling or delinking the two countries, they may grow apart in some respects, but they're going to continue to have certain connections. I think there's a certain element of, and it's not my business to endorse or criticize the U.S. administration on anything, but I think there's certain aspects of what's going on that U.S. could have taken actions earlier under the Bush administration, the Obama administration, or earlier in the Trump administration, that to take some of these actions are somewhat understandable, in the sense that in the economic relationship between the U.S. and China, for years, China was benefiting a lot, and U.S. corporations, companies that were wanting to reduce their labor costs, for example, they were, from my home state, North Carolina, they were sending a lot of jobs to local places elsewhere where they were going to be cheaper labor. And industry was willing to do that with the promise that they were going to have access to the Chinese market. So it was kind of this bargain of, I'm going to be able to manufacture my goods in China cheaper so I can reduce my prices for U.S. consumers, which is a positive thing in some ways. And at the same time, I'm also going to get access to that Chinese market to sell to 1.4 billion people. The second part of that, in some ways, didn't materialize like those companies thought. And the result is that the U.S. did lose a lot of jobs. Now, it's not to say that everything that has ever happened bad in the United States is China's fault. But one of those dynamics is, I just don't see it going back, that element of the relationship. I don't see a bunch of U.S. political leaders under this administration or future administration saying, you know what, we're going to encourage businesses to send more jobs to China. And that, I think that the toothpaste is out of that tube. It's not going to happen again. But it's a matter of, what is the relationship going to look like in the future? And you see with China exploiting freedom of speech within the U.S. by sending their government news agencies to the U.S. as well as in Australia, leveraging the open society of Western democracies, right? To your advantage to try to shape and influence the local population. The U.S. now requiring those reporters to register as federal foreign agents, as if they were, government arms. So
ultimately, I think that's one of our strengths, though. Actually, our open society. I think that's one of the reasons why the West won the Cold War, because while it creates certain weaknesses, it is actually ultimately a strength, I think, to be open.
And I agree with you. And I think one of the ways is that more information is better. Yeah. And so even though Twitter, for example, is not a government agency, what they've started doing with all the Twitter accounts that are used by Chinese foreign reporters, as well as spokespersons for the government, they now label that this is a state-affiliated person. And I think that that's valuable, because they're still allowed to express their views. Yeah. But the consumer is more informed to say, oh, I didn't realize that China Daily is actually run by the Chinese Communist Party. And so hopefully consumers are more informed when it comes to the marketplace of ideas on what they're buying.
So it's not going to be business as usual. It's going to be business as unusual, perhaps. So
perhaps.
John, thank you very much. Wonderful to hear your views and opinions and ideas. As usual, incredibly comprehensive. You really know a lot more about the law than I am ever going to know in about 10 births. So terrific.
No worries.
Thanks so much, John. No worries, mate.
Thank you.
See you later.